Afternoon for the rest and Loudon swap. As Tom just mentioned, Tom Madden just mentioned, we're recording this today. We don't usually do that. We don't usually share recordings. We really want people to participate in person. That's what this is all about. But if you need the recording at a later date because there's something specific asked and you want to go back to it, I guess we can do that in this particular case. So my name is Clarissa Russell. I am one of the program coordinators for the Rest and Lounge Swap, which has been around for years. And we have two other colleagues who are not here today, Louis Flack and the other Tom. And I never pronounced his name correctly, so I can let Tom Madden pronounce the other Tom's
Yeah,
name
it's
for
it's
me.
Tom Chokas. He is with M&T Bank. He works with foundations and nonprofits. And then we have Louis Flax of Flax and Associates. He helps his association clients with their sponsorship programs. My name is Tom Madden. I'm the other co-host today, and I own Visual Impact Productions. We're a full service video company, and we help our clients with video content, whether it be on the website or social media. So go ahead and Carissa, kick it off, and then off we go.
So we're really fortunate. We've got Jeff Tannenbaum here today. He is a lawyer and he works with associations as well. Many of you may know him because he has been a resource to many of us over the years, and we really appreciate that. So Jeff has agreed to answer any questions that we may have. And one of the things when you registered was an opportunity to submit some questions. So we will start off with letting people raise their hands and see what question they have. And if you don't want to do that, Jeff has a list of questions that we could possibly go through as well. So,
Or Clarissa, we can also, you know what, it might work better, Clarissa, is that they
okay,
they just put their questions in the chat.
okay, we can
That
do it
way
that
you
way.
kind of because there's a lot of questions, and then we don't want to take somebody out of turn. So
Okay.
if you have your questions, everybody just put them right in the chat, and we'll go one at a time. If you want to do it that way, or we can just start with some of one of the questions that I saw. And Jeff, you may have seen some of the same things, but I can kind of start it off unless somebody wants to put it in the chat. But let me look in the chat. I saw some questions that regarding AI. That seems to be a really hot topic. Effective and ethical use of AI in associations. Did you want to start with that one, Jeff? Since that's probably one that everybody worries about today. I know in my business, in the video business, I worry about it, and people ask about it all the time. So if you can share with us what you know. Actually, we're kind of jumping ahead a little bit, Clarissa. There's something that we asked our speakers that about them that nobody
That's true.
knows, and Jeff did have a secret. So go ahead, Jeff, if you want to tell us a
Sorry about
secret.
that.
I don't know that I would call it a secret, but maybe not something that everyone knows about me. Well, just so everyone knows, I'm Jeff Tenenbaum, managing partner of Tenenbaum Law Group. We are a six-lawyer boutique law firm based in Washington, D.C. All of our clients are associations and nonprofit organizations. We represent hundreds and hundreds of organizations each year, primarily national and international nonprofits and associations as kind of outside general counsel. I've been doing this for 30 years now, all of it exclusively representing associations and nonprofits in private practice here in DC. I do a lot of speaking and writing on association and nonprofit legal issues. I have for many years. And I know a number of you saw the registration list and even saw some of you yesterday at a speaking event hi Christine, that I did yesterday for the Nonprofit Advisory Board. But so everyone, in the association world, nonprofit world may know that a nonprofit lawyer, but a lot of people don't know that I've actually written two books in my career. One was published by ASAE. It's a super exciting book called Association Tax Compliance Guide. Has no pictures. It's a surefire cure for insomnia without question. But it is a great resource. But I wrote a second book a few years ago in the early part of the pandemic. I have always been kind of an amateur mixologist. Was a bartender in college and in the years that I worked on Capitol Hill after college, and have always had a tendency to come up with fun, creative cocktails, which I started posting a lot on social media in the early days of the pandemic, and then later turned them into a cocktail book called Quarantine Cocktails that I published about 3 years ago, with a whole bunch of fun pictures and cocktails of every variety. So I do have fun with that, and actually, this happened to coincide today with my latest cocktail that I will be making this evening for a neighbor of mine called which I'm calling a smoked Mexican corn old fashioned. That's going to be pretty fun. I got these two Mexican liquors that I found, this
Yeah.
Mexican corn whiskey and a Mexican corn liqueur. I have some smoked orange and black cherry bitters, and I have some mesquite chips and a little flame to burn to smoke the cocktail, and it should be a pretty delicious cocktail that I will be making this evening. Sorry, we're not having an in-person event where I can make it for all of you, but maybe that's a task for another day. So, with that,
Yeah.
Tom, I'll turn it back to you with your questions. And on
Sure.
the AI issue, was there a specific question that someone had, or do you just want me to
Well, so yeah,
speak to more
no,
generally?
just as here, effective and ethical use of AI in associations. And again, I get the question all the time since I'm in the video business, and there's some people that will take it and try to use it and do funny things with it. But I think it's a big thing on people's minds. You hear it in the news all the time. So the question is basically, what can associations do to effectively use AI ethically, in their associations?
Okay, so first off, I'm not going to really speak to the ethical part of it, not because I'm not an ethical person, but because that's a little bit outside of my wheelhouse, and I don't tend to opine on the ethics of what nonprofit or association executives should do. But I will speak to the legal issues. Secondly, I just posted in the chat a link to our website, tannenbaumlegal.com. And I put that there because we have a ton of resources on our law firm's website. If you go to the tab called Resources, you'll see subtabs for publications and recorded webinars. We have a ton of hundreds and hundreds of articles and PowerPoint presentations and recorded webinars on a wide variety of association and nonprofit legal issues, including several fairly recent ones on the topic of AI and associations and nonprofits. So I would direct you there, and for other things that we talk about in the next hour, where we have resources on the site, I'll direct you to them. But in the AI space, look, this is rapidly evolving. As we all know, how associations and nonprofits utilize AI is rapidly evolving. And this topic came up at the program that I was a panelist for yesterday. Um, and some of my other co-panelists were, all talking about their organization's use of AI. And, they're at different places and they have different experiences. But one of the questions that was posed to me yesterday by the moderator, which I think is a good one to start today, is I was talking a little bit about AI usage policies and how important they are for associations and nonprofits to have. And she asked me, a cart before the horse question, should you start using AI, try to figure it out, and then develop a policy, or should the policy come first? And I said, sometimes it's not clear, but in this case, I think to me at least, it's absolutely clear that the policy needs to come first. You absolutely need to have a policy that regulates how your employees, your contractors, your volunteer leaders, your board members, your committee members are going to use AI, if they are going to use it, how do they have to use it? What are the rules of the road? What are the guardrails? What are the prohibitions? Things like that. That's really important. Second thing, in terms of the legal risks of AI for associations and nonprofits, I kind of put them in maybe four key areas for the moment, but I'm sure this will evolve over time. One is copyright protection, protecting your copyrighted information and documents, and avoiding copyright infringement. That's a key area. Second is privacy and data protection. Third is discrimination and bias in employment, in scholarly and scientific and medical journals and publications, even in things like board member and volunteer leader selection. And then the fourth would be tort liability. Like say you put out standards, you put out clinical practice guidelines as an association or whatnot, and people are relying on those. And to the extent you use AI or your standards committee or your staff or others are using AI to help develop, fine tune, refine those sorts of things. And if there's not enough proper vetting, and there's actually inaccurate or incomplete or dated information in their standards, and that causes harm to folks, you can create liability risk, tort liability risk for the association. So these are kind of the four areas of legal risk. In terms of how to mitigate them, I think it really starts with the AI usage policy. And while there's a lot of different things that are important to do, there's a few key principles that I've, for me at least, that I've pulled out that we try to drill into clients that we build into our AI usage policies that we work on for clients and whatnot. One is that whatever comes out of an AI platform, an AI tool, there has to be sufficient human vetting of what comes out. And again, this is not just by the employees, it's by your volunteer leaders and your committee members and your contractors and your speakers and your authors. That you need to get representations and warranties from all of them. And for your employees, you need to mandate that anything that comes out of the platform has to have sufficient human vetting of that for accuracy, for completeness, for timeliness, for every other aspect to make sure it's not, things that come from an AI platform are going to have inherent built-in biases because it's pulling from, information out there on the internet and whatnot that has built-in biases. We all know that that's been well documented. And so if you're going to use, for instance, AI in your recruiting or hiring or vetting process for employees or volunteer leaders, you need to be sure that you are weeding out any potential built-in biases. You need to be sure that everything that comes out of that is accurate. If you hope to register works that you're creating, which with the U.S. Copyright Office, which every association and nonprofit should be doing, the Copyright Office, copyright law says that you cannot register something that's not a product of human creation. And if it just comes from an AI platform and there's not enough human input into that document, it's not going to technically be subject to copyright registration and copyright protection. So for all of those reasons, that human vetting is really important, and you need to mandate it, require it. You need to have representations and warranties in your contracts with your contractors and your speakers and your authors where they are representing that they are going to do that. And I'll tell you one other key kind of principle, and then I think we should move on to other questions. I could go on all day on this. But another key thing is this concept of a closed AI platform. So when I say closed, and I'm not a tech expert by any means, so I don't know all of the different terminology, but basically, AI platforms can either be an open system or a closed system. With an open system, what we're talking about is anything that gets put into the system. This is going to be the default, for every AI platform from ChatGPT to most of the others, with the possible exception of Claude, is that these are open systems, meaning anything you put in, the AI platform trains itself on it. It learns from it, and then it gets incorporated into everyone else's AI queries that they're using. And so anything that you put in is going to have the potential to come out. And so that means if you're putting in confidential or proprietary information, if you're putting privileged information, if you're putting in PII, personally identifying information, all of that runs the risk of coming out at the other end in a way that could do great harm to your organization. And so, if at all possible, especially for your staff, who obviously you have the ability to regulate more than anyone else. You want to mandate that they are only using a closed platform where the AI's ability to be trained and learn from the inputs is not there. So everything just stays a closed circle within your organization. And ideally, what we're seeing a lot of our clients doing is paying for an enterprise version of, say, you pick your favorite platform, they all have them, where the association or nonprofit can subscribe to an enterprise version of that, ensuring it's a closed platform, and then mandating that employees that want to use AI for the work have to do it only through that enterprise version of the platform. And what a lot of associations are doing is they are purposely putting a whole bunch of really important information, data, documentation in there so that they can, their own internal, it's almost like, think of it like a customized AI platform. And they can use it with all of those inputs to help develop, outputs that are customized, for their particular industry or profession or whatnot. So there's a lot of great opportunities there. There's also, obviously, as I just described at a high level, a lot of legal risks. So making sure you have a solid AI usage policy, I think, is a critical first step.
Awesome. Thanks, Jeff. So, Clarissa, it looks like you were sent a direct message earlier by Paul Miller. And Paul, it's pretty long, so I think it'd be better if you were to ask the question. If you could take yourself off of mute and ask the question.
Actually, hold on.
He
I'm not
sent it.
on mute.
Yeah,
Oh, he sent it. I'm
yeah, he
sorry.
sent it directly. Paul, are you there?
Yeah, yeah. Thanks to I just sorry
Yeah, go
for
ahead.
sending it to both. Yeah, I didn't want
Yeah,
to
no
have
worries. Go
somebody
ahead.
miss it.
Yeah.
Uh, now I'm going to switch 180 degrees into a different topic from what Jeff was just talking about, which was interesting. So again, from another world, from the meetings and venue contracting world, uh, hotels are more and more these days when entering into venue contracts, when groups are trying to enter into venue contracts with them. It's quite standard that there'll be a cancellation clause that addresses what happens if the group were to cancel on the venue. More event organizers now are catching on to the fact that there should be language in the contract that pertains to what were to happen if the venue were to contract on the event organizer.
You
Uh,
mean cancel? I'm the event organizer,
I'm sorry. Yes,
not
thank you.
contract.
Thank you. Yeah, yeah, yeah. Uh, so if the again, it's quite typical for the most contracts to spell out specific dollar amounts that increase as the dates of the event draw nearer. Uh, and then in the years past, more times than not, I personally, just one anecdote here, have been able to get hotels to agree that the language that would pertain to language that if the hotel were to cancel on the group, that language would basically say any damages that would be incurred by the group without a cap, if they're as long as they're reasonable and clearly demonstrated, would be potentially owed by the hotel to the group. I have in the past few months, and I'm just wondering now if this is a trend or if it's just again Paul Miller's little lone world. If that hotels are now saying no, we have to cap it, and that we will that language of if the group cancels on the I'm sorry, if the hotel cancels on the group, will mirror the damages if the group were to cancel on the hotel. I'll flash back probably decades ago. I began being brainwashed by other meetings industry hotel lawyers that I took away from their uh, recommendations that to mean that a judge, if there was a dispute and that contract were to be put in front of a judge would potentially throw the contract out and say, this contract's BS because there's no way the damages owed by one party or possibly incurred by one party have anything whatsoever to do with the potential damages incurred by the other party. And so I'm trying to see if any legal advice has seen a trend along those lines or if there's any insights along those lines. I hope that makes sense.
Yeah, Paul, let me respond real briefly with a few comments and observations. First off, we do a ton of hotel and convention center contracts for associations. We work on probably several every single week, sometimes more. So we do have deep experience with it. And our firm, which started 6 years ago, in January of 2020, we lived and breathed hotel cancellation contract clauses and force majeure provisions throughout 2020 and 2021 when COVID hit. Um, Secondly, I don't know, and we have more experience than most, and I don't know that we're seeing any trends on this particular issue. We are certainly seeing other trends, like since COVID, for instance, the hotel contract negotiations have just become a lot tougher, without question. And hotels have dug their heels in more, and it's just a lot harder to get the kind of concessions we were getting before. And I could go down and drill down more detail about trends we're seeing with certain types of provisions, but not on this particular one. Third, um, so that this kind of not to bore you with contract law that every lawyer has to take in the first year of law school, but one of the things you learn in contract law is that if a contract does not provide for actual damages are like money damages that you suffer as a result of a breach, a material breach of the contract. And if the contract is silent on damages, then if one party materially breaches the agreement, like by canceling it, then the other party is going to have a right to collect whatever actual damages they can prove that they incurred as a direct result of the breach. However, most hotel contracts, and as you mentioned, it's the norm to override the actual damages, the requirement to prove actual damages and to put what are called liquidated damages in the contract instead. And that is an agreed upon amount that, the parties agree that if one party materially breaches the agreement, such as canceling it without good reason or without, the force majeure clause kicking in, then, if the association cancels, it's going to owe the hotel X amount of money. And like you said, it's typically a sliding scale based on time, that the closer you get to the event, the greater the damages go up. But these are the liquidated damages. So it's what the parties agree to pay in the event of a, essentially no cause cancellation that's not excused by, say, force majeure or something else. And on the flip side, if you can get the hotel to agree to some form of liquidated damages if they were to cancel. And usually the only reason they cancel, other than maybe the hotel's not available because of a fire or maintenance or something like that, would be if they decide to bump, what people call bump the association in favor of a larger group or a more profitable group, a group that has, higher room rates or paying more in food and beverage or whatnot. And the hotel might make a calculated business decision to cancel the smaller association contract in favor of the bigger one. But if the parties agree on liquidated damages, even the damages being the same liquidated damages if either party cancels, if they agree to that, then no judge is going to toss that. That's going to be, what the parties agreed to for liquidated damages. Now, I will say it's not the norm to be able to get a hotel to agree to liquidated damages that are the same, for the hotel to pay that the association would pay. That would be highly unusual. And you could also make an argument they should not be the same because the actual damages, suffered. Like for the hotel, it's usually pretty easy because the actual damages are going to be the profits they would have earned, right? If the meeting had gone on. Whereas in the other direction, if the hotel cancels on the association, there's certainly profits, like if the association couldn't hold the conference at all, but usually they're going to try to find another venue. And so whatever transition costs they have, having to agree to a new contract at such a late date, there are going to be higher costs, but they wouldn't necessarily be the same. But bottom line is, I don't see any real trends there. It's like any other contract negotiation. The more leverage you have, like the larger your meeting is, the more leverage you're going to have to be able to negotiate provisions like that. But I think to be able to negotiate a provision where the liquidated damages are the same if either side cancels would be highly unusual.
Thanks, Jeff. That was excellent. I appreciate the insight.
Yeah, and let's try to move on to, because took a lot of time on that. If we could just try to move on to some other topics or issues, including if there's other hotel contract questions, it's fine.
Yeah, so Clarissa, you have one, I think.
So, yeah, Jeff, you just mentioned that you haven't seen that trend since COVID, but that you kind of alluded to maybe there's other trends that you've seen since COVID has come around. Do you want to just share what some of those trends may be and not like speak to anything a specific legal question, but what is occurring out there? Where are you seeing, what are your clients coming to you more with than they used to?
Well, I mean, they generally come to us and they say, we have this draft hotel contract for this meeting. Can you review it? That's almost always what they say. And then sometimes once we do our markup, we send it over, they send it to the hotel. Hotel comes back with some, they accepted some, they push back on others, they give alternative language, and then we're reviewing that as well. I think the biggest trend is just that hotels are being tougher. They're not making the kind of concessions they were before. I mean, there's all sorts of things that we try to negotiate. We try to negotiate lower cancellation penalties. We try to negotiate more opportunities that if we're canceling further out, the penalties are lower. We try to make sure that the liquidated damages are really only delivering lost profits to the hotel, not gross revenues that they might have lost. We're trying to, on attrition. So attrition is different than cancellation. Attrition is when the association doesn't meet its minimum targets for room night revenue and food and beverage revenue. Those are typically the two big categories. And again, you want to build in an ability to reduce your minimum targets for hotel room revenue and food and beverage, usually by maybe up to 15%. But you want to have because I'm usually not going to let you do more than that, but you want to have an ability to reduce those amounts if you need to, as you get closer to the event. They're not going to let you do it 2 months out, 3 months out. But, the more opportunity you have, it looks like your meeting is not going to be as big as what you thought. You're not going to have as much attendance. You want to maximize your ability to try to reduce that. You also want to, for instance, how attrition is calculated, like particularly on the room night revenue, you want to make it throughout the duration of the conference, because usually these are multi-day conferences for most of these. And you want to have it calculated in total, in the aggregate, adding all of the nights together, not on a nightly basis. That's generally going to be more to the advantage. We deal with a lot of issues where the hotel is doing construction, or part of the hotel shut down and they're doing loud construction, or one of the restaurants and bars is closed, or it's a nice, warm weather venue and the pool is closed for renovations. Like you want to require the hotel to give you adequate notice in advance if something like that happens, and using that as an ability for you to get out of the contract without penalty. So, I mean, I could go on and on. I don't want to spend too much of the time on this. So, I don't know that we're seeing any trends so much as we are seeing the hotels just digging their heels in more. We're not able to get as many of the concessions that we used to be able to get. But again, every negotiation is different and it's going to depend on leverage. The smaller meetings have a lot less leverage than the larger ones for sure. And when we have some clients that, have these citywide events and they take over, 12, 13 different downtown hotels and the convention center. And those, working with the Convention and Visitors Bureau, we usually have a great opportunity to get all sorts of things like no attrition at all built into the contracts and things like that. All right, what
Okay.
other questions do we have?
Yeah, we got some bubbling up here. Clarissa, do you want to mention the ones that just came in about like Joan had a couple?
Let's try to move on from meetings if we could.
Okay. Actually, there was
Go
another one
ahead.
here. I noticed I kind of looked at them earlier. So Tanika Coates asked the question about how the new administration with nonprofits, things they should be aware of in 2026 is regarding what's happened with the administration. Tamika, did you want to expand on that a little bit?
Sure. So good afternoon or good evening. My organization, we were dealing with grants, and of course, our grants were terminated. And so there's a lot of other organizations like that. And so I'm just, keeping abreast of what's going on with the administration and how some of the, I guess, rules could impact what's happening moving forward. And I just wanted to know if you're aware of anything that we should be aware of that may be coming down the pike as far as nonprofits when it comes to that area.
Yeah, so I'd probably give 75 to 100 presentations a year these days, and this year more than half of them by far have been focused on threats to nonprofits and associations from the current administration, without question. So everyone is talking about this, everyone's concerned. Yesterday at the program I did, there were a number of questions about this. Let me say we have very limited time, so let me just say a few things at a high level. And there are some really good resources on our firm's website about this stuff too. First off, as so many organizations like yours, Tanika, know that organizations that receive particularly grants, like there's three types of or four types of federal awards. There's grants, cooperative agreements, contracts, and loans. Um, it's the grants that have been most affected so far by this administration in terms of monies to nonprofits. Contracts, much less so, but grants and cooperative agreements, which are kind of in the same category, they're both governed by the Uniform Guidance. But the grants that were made in the past or that were promised to be made for causes, issues that really don't align with the administration's priorities. You can imagine, what those things are, everything from conservation and climate to minority rights to immigrant rights to so many other things. Those are the areas, LGBTQ plus rights. These are the grants that have been cut by the administration and that are almost certainly not coming back. And so obviously that's a direct impact. In addition, the Office of Management and Budget has mandated that every federal grant agreement have a provision be inserted in there like for renewal grants or for new grants that are into, that says that the administration has the right to terminate that grant for convenience. And it's, it doesn't have to show cause. It doesn't have to show anything except that it wants to terminate it. And of course, you could write that provision into any contract, any grant agreement, but they're insisting on it. And from their perspective, that's probably a wise move from a legal perspective. So that's something that's going to impact everyone going forward. Also, if you are lucky enough to continue to receive your federal grants or get new ones, what you're generally having to do, an officer of your organization is having to sign a certification, uh, among other things, maintaining and attesting, representing and warranting that your organization does not engage in any illegal DEI practices. And this is signed under penalty of perjury pursuant to the Federal False Claims Act, which is pretty serious. Um, Beyond federal grants, there's kind of two other primary areas of legal risk, both of which predated this current administration by at least 2 years, um, and particularly through litigation. And they really started after the U.S. Supreme Court's 2023 college admissions decision that said it was unconstitutional and illegal to give any race-based preferences in college admissions. In that decision, those decisions, which essentially adopted a reverse discrimination line of reasoning, have been utilized by even the same plaintiff who brought those cases and others to bring lawsuits against nonprofits and for-profits in two different areas. And so this litigation has been going on for 2 years, 2+ years. I mean, some of it predated it, but it's really exponentially expanded. And of course, once the administration came in, kind of added fuel to the fire in terms of these sorts of lawsuits. One is in the employment area. And again, this is all about reverse discrimination. In fact, this entire administration, DOJ, all of the federal agency offices of civil rights, their focus has completely flipped. It used to be focused on discrimination, harassment against minority groups. Now it's all about discrimination and harassment against majority groups, like think the straight white guy. That's what has been the focus of the administration, and that is what has been the focus of so much employment litigation by employees at the federal and state level, alleging that the majority group individuals have been discriminated against in favor of minority group individuals, whether it's preferences in hiring and promotion and compensation, in harassment and other things like that. And then that trend has only accelerated this year. It accelerated this year after the U.S. Supreme Court in June issued a unanimous decision, which said that the long-standing, decades-long precedent that used to hold that if you were a member of a majority group bringing an employment discrimination claim, you had a much higher bar to satisfy in order for the case to move forward. The court, in a unanimous decision, rejected that and said, no, discrimination is discrimination, whether you're a member of a majority group or a minority group, and there should be no higher standard if you're a member of a majority group. And so that has only triggered a lot more employment litigation. And of course, at the federal level now, the U.S. Department of Labor and the EEOC have been very aggressive in kind of adopting this new kind of reverse discrimination focus. The third area, or the next area of big risk beyond, federal funds being cut, federal funds also pursuant to Title VI of the Federal Civil Rights Act. You cannot use federal funds in any way that discriminates on the basis of race, color, or national origin. So we've got federal funds risk, we have employment risk, and then the third area of big legal risk for nonprofits and associations comes from grants, scholarships, and fellowships. And that's because Section 1981 of the original Civil Rights Act of 1866, which was enacted at the end of the Civil War to protect the rights of the then freed slaves to be able to earn a living, makes it illegal to discriminate in contracting on the basis of race. So for decades and decades, that provision was used by minority group individuals to be able to protect themselves when they believed they were subject to race discrimination in contracting. Well, again, after the 2023 U.S. Supreme Court college admissions decision, that got flipped on its head. And now there's been a ton of litigation filed, including many suits against associations and nonprofits like the American Bar Association, American Chemical Society, lawsuits against the Fearless Fund, complaints against Academy Health, complaints against the Bill and Melinda Gates Foundation, all of which claimed alleged that these groups, grant programs, scholarship programs, or fellowship programs, all of which involve a contract, because they had or have eligibility criteria that limit eligibility to people of certain protected characteristics, including race. And race also includes ethnicity for these purposes, that they were a violation of Section 1981 of the original Civil Rights Act and therefore illegal. And these cases have almost across the board been very, very successful. And the defendants in virtually every case have either abandoned their programs like the Fearless Fund did, or changed their eligibility criteria like the Gates Foundation and Academy Health and others did, to say, okay, we're no longer going to limit eligibility based on race and other protected characteristics, but we're going to limit eligibility on other things that don't involve race. Things like income or financial need, or things like chosen career path, or first generation college students, or other things like that. But keep in mind that Pam Bondi, Attorney General Bondi, issued a memo in late July of this year where she said, this is in employment and in this Section 1981 contracting area and in other areas. She said, don't just focus on things that speak to race specifically. She said, look at proxies for race and other things that could be viewed as a proxy for race. So she said, for instance, said a lot of things in that memo, but one of the things she said was that if you're an employer and you're primarily recruiting just from historically black colleges and universities, even though we know that HBCUs admit non-black students into those universities, but we also know that the predominance of graduates are black students. She said that that would be a proxy for race, and that would be viewed as illegal discrimination in kind of your recruiting practices for employment. So you need to think broadly when it comes to things like this. So those are the primary areas of legal risk. The other area that's been getting a lot of focus and concern by a lot of folks involves federal tax exempt status. Now, this has been going on all year long. We've seen just a ton of folks talking about it, commentary back in March and April. There was all this concern that the IRS was going to be rewriting the rules for Section 501c3 eligibility to make it so that conservation and climate focused groups were going to be no longer eligible for C3 status. That ended up not happening. And the White House even issued a statement saying it was never going to happen. And by the way, I just posted a link to an article that I just updated in the last few days on our website called How the IRS Can and Cannot Revoke Federal Tax Exempt Status. And one of the things that people are worried about now, just less than a few weeks ago, the U.S. Department of Education, relying on some IRS precedent, issued final regulations involving the Public Service Loan Forgiveness Program. And this is discussed in that article I just posted a link to. That program has been around since the first Bush administration. And what it does is it says that if you're a college student with student loan debt, federal debt, and you go to work for a government agency or a 501c3 nonprofit organization, and you work there for a certain period of time, that you can have your federal loans either partially or completely forgiven. I don't remember the details. And it used to be any 501c3 organization. Well, no longer. Now, kind of borrowing on some longstanding IRS precedent, what the Department of Education said is that if you are a C3 organization that is engaging in a substantial illegal purpose, then you are no longer eligible to participate in the Public Service Loan Forgiveness Program. And when they go through and they highlight what are examples of a substantial illegal purpose, they talk about things like aiding and abetting violations of federal immigration laws, supporting domestic or foreign terrorism, aiding or abetting illegal discrimination, like employment discrimination or discrimination in scholarships or grants, or violating state tort laws, including those against trespassing, disorderly conduct, and public nuisance. There's also references to abortion. There's references to transgender care and other things that, not surprisingly, align with this current administration's priorities. And so as a result of that, now that just involves the Public Service Loan Forgiveness Program, but a lot of folks believe that that may be a precursor to the IRS starting audits, examinations of organizations that fall into some of those same categories. So it's something really to keep a close eye on. The article, though, also does talk about how there is no way except for Section 501(p), which gives the president, through an executive order, the ability to immediately suspend the tax-exempt status of an organization it believes is supporting foreign terrorism that was enacted in the aftermath of 9/11. Other than that, the only way to revoke exempt status is through the very extensive IRS audit and appeals process, which provides a lot of protection for nonprofit organizations. So if you're interested in that, I would encourage you to take a look at that article. So that's kind of a very high level overview. Tanika, I hope that helps you. Certainly, I could talk all day about this stuff, but I think we need to move on.
Well, thank you. That was great. And yeah, you deserve a glass of water and a round of applause. That's a lot of information, very informative, and you touched on some things I hadn't even thought about at all. I'm sure many other people haven't as well. So Laura Cummings has got a question. So Laura, if you want to come on camera and ask your questions, that would be great.
Sure. Good afternoon. We've been getting a lot of emails the past several months about the Secure 2.0 Act stuff. And we have a pretty good retirement administrator. And so I feel like they're keeping us up to date about it, but also I'm not an HR person. We don't have an HR person at our firm. We're small. So I'm just wondering if there's any Secure 2.0 implementation things that you think, any of the clauses you think we should be kind of keeping our eye out for in particular. Like today, we just dealt with the Roth catch up one, and so I had to work with our payroll processor on that to make sure we're doing it right.
So I should have said this at the beginning. Most of the questions, I do a lot of these Ask the Association, Ask the Nonprofit Lawyer sessions, and the vast majority of the questions I can speak to. But once in a while, there are things that are very specialized that we rely on what we call outsourced counsel, who are very specialized lawyers in certain areas, like employee benefits, to help deal with things like this. So unfortunately, this is one that I just cannot speak to. But if you have any specific questions, just email me, and my email is usually, you can find it on our website.
Sure.
And I'm happy to connect you with our benefits lawyers, so I'd be happy to answer your question.
All right. Thank you.
Tom, there was a question I saw in advance on which I heard some buzz about, like ASAE, Collaborate forums and whatnot, about this new Washington state sales tax on live events. I might speak to that for a second, if that's
That'd be
okay.
great.
Sure.
Yeah.
I also another one from Amy Matthews. If you had a question, I'll let you know about that. I saw as well. So go ahead
Okay.
and talk about that
Let me
first.
talk about this one briefly. So, now you might be thinking, well, we're based in Virginia or DC or Maryland, and we don't have, or I guess maybe for this group, it's largely folks in Virginia. But what do we care about a Washington state sales tax? Well, the reason you need to care about it is that look, sales tax is a state-based issue. It always has been, and states have broad discretion to determine on what sales tax can be assessed. And here we're talking about, there's two different types of approaches to two different aspects of sales tax. One is what you have to pay on purchases. Okay, that's kind of the payor. So you purchase food and beverage at a conference you're holding in pick your state. And if the state has a state sales tax, which most do, you're going to have to pay state sales tax on that food and beverage unless you have an exemption in that state. But then we have on the flip side, there's an obligation for sales and use tax collection. And that means if you are selling products or services that are subject to sales tax in the state, then you're obligated to basically charge that sales tax to the consumer, whether in your case it's like a member or a conference attendee or purchaser of a publication, and then you have to send that sales tax to the state. Again, unless you're subject to an exemption. And there's far less exemptions for the sales and use tax collection side than there is on the purchasing side. But it's a big obligation for sure, but it's even a bigger obligation when you have, say, a nationwide association that has members maybe in every state and is holding events in every state. But back when I started practicing 30 years ago, so many state sales tax were focused, almost exclusively for the most part on products, not services. Well, states realizing how many great revenue opportunities there were out there, for decades now have been expanding their scope of what's subject to sales tax to include all sorts of services as well. And it's sometimes in every state it's different, but sometimes they're very, very specific. But what the new Washington state law says, which took effect on October 1st of this year, just about 2 months ago, and what it says, it is a sales tax on events that occur in Washington state. But the rules from the Washington State Department of Revenue make very clear that it also includes live webinars where the attendee is based in Washington State. So again, this is only if you are charging for things. If it's a free webinar, this should be a non-issue. But if you are charging for participation in, say, a webinar or a virtual conference or something, and the attendee is in Washington State, you are obligated to collect and remit that sales tax for that particular attendee. Obviously, if there's multiple attendees, you're doing it multiple times, and then remitting that to the state. So this is pretty significant. I mean, I'm not talking significant in terms of the dollar value, because in the end, theoretically, it doesn't cost the association anything. You're just charging extra and then you're remitting it to the state. But the administrative burden is significant. And so, yeah, if you have a Virginia-based association and you are doing any sort of a live event, it seems to exclude like recorded things. And obviously, it only applies if there's a charge. But if the attendees are in Washington State, then you're obligated to do this. And of course, if you're holding a conference in like Seattle, Washington, you're going to have to do it for all of your charges there as well. So something just to keep an eye on. And whoever you work with on sales tax compliance, it's typically either your CPA firm or a specialized firm that helps you with this stuff. You're going to want to be sure to comply with that law. All right, Tom, you said you had another question.
Amy Matthews, she had a question regarding the fully remote offices. And then as far as they're in Maryland, they were in Maryland, but she had a question about the some regulations regarding that. How do you manage that? Amy, did
Yeah,
you want to come off? Amy, is Amy
Sure,
there?
thank you. Hi,
Sure.
my name is Amy. We're with a nonprofit and we had a bricks and mortar office we leased in the state of Maryland, and then the staff became fully remote, and now we have no employees in the state of Maryland. But we still need to be registered as a foreign entity in the state of Maryland. And I'm trying to find a way to find a physical address, and all the virtual office address things I'm finding come up as commercial receiving addresses by the US postal system. So they're getting flagged, and like I can't change my bank address to the virtual office because it recognizes it as a PO box. How are you advising and there's got to be tons of organizations going through this.
Yeah, there are. All right, so I'll answer your question, but I'm also gonna use that as an opportunity to speak a little more broadly to this whole bucket of issues because it's so prevalent for so many associations, and not just those that are 100% virtual like yours. And we do have, of our hundreds of clients, we do have some that are 100% virtual. We also have many that have a brick and mortar facility, an office, but then they also have employees that work all across the country, some in the DMV area and some all across the country. So a few things to keep in mind. So it's not always intuitive what state's laws are going to apply when. So for instance, if you are, I'm just going to make for purposes of this hypothetical, say that your association is incorporated in Maryland. So even though you have no brick and mortar office in Maryland, and you might not even decide that Maryland is going to be your headquarters state, and you're right, for so many different federal and state legal reasons and regulatory reasons, you do have to have a state that is deemed to be your headquarters state. And for a number of purposes, you can't just have a PO box. You have to have some sort of a physical address. And by the way, there are companies out there that will satisfy these requirements where you don't actually have to be renting office space. I don't have a list for you, but there are plenty out there. If you just post it on like an ASAE Collaborate forum, I'm sure you'll get lots of great feedback. There's one that a lot of them use that starts with an R. I don't remember the name of it. But anyway, there are plenty of companies out there. So you do have to do that. But regardless of, say you decide to be in DC, okay, as your headquarters state, and you find a company that's going to give you a physical address in DC. As a Maryland corporation, a Maryland nonprofit corporation, you are still governed by the Maryland Nonprofit Corporation Act, irrespective of the fact that you might have no other tie to Maryland. And so as a result, these state nonprofit corporation acts primarily deal with governance related issues. Think of things in your bylaws. They also deal with other things like mergers and dissolutions and transfer of substantial amounts of assets and things like that. But it's primarily governance focused. And so and your bylaws always have to be consistent with that state nonprofit corporation act. And these state laws, they vary from state to state. We know them intimately. They're not all the same. So that depends on where you're incorporated. Also, for things like the Uniform Prudent Management of Institutional Funds Act for C3s, that's generally going to be governed by your state of incorporation. But for other things, like for instance, whether and where you have to pay or collect and remit sales tax, that's obviously based on where the purchaser is located. For purposes of state charitable solicitation registration laws for C3s, that's going to be based on where the individuals are located whom you are soliciting for charitable contributions. And for employment, generally speaking, there's a few exceptions, but generally speaking, it's going to be based on where the employee is primarily working from. And primarily, usually most of the states define as like greater than 50% of the time. And so this is really important. Like we have one client, we're just helping with some state, employment and HR compliance issues. They have employees in 40 states across the country. And so every one of those employees that's in a different state is subject to that state's employment laws. And the state employment laws vary wildly from state to state. Some are very employee friendly, like think DC, Maryland, certainly California, New York, Massachusetts. Some are very employer friendly, like think, Virginia and Texas. And so it's very, like, for instance, if you have an employee in Florida, which is also very employer friendly, Florida has a law on the books. It's currently on hold from a federal appellate court, but they have a law on the books that makes it illegal to provide any anti-discrimination or anti-harassment or unconscious bias training to any employees located in Florida. Okay, so even if you're a remote association, you have a Florida employee, if that law takes effect again, you're not, if you otherwise provide mandatory training for your staff, you cannot allow the Florida employee or employees to participate. If you have a non-exempt employee in California, I'm just giving you a couple examples. California requires that non-exempt employees that they be paid overtime, not on a weekly basis like federal law requires. In federal law, if you're non-exempt and you work over 40 hours a week, in a given work week, you have to get paid time and a half for every hour over 40. In California, it's calculated on a daily basis, on an 8-hour a day daily basis. So if you are having a conference, and the employees, even if the conference isn't in California, but you have some California-based employees and they're working 10, 12-hour days for 3 days in a row, and then you give them the rest of the week off. As a result, you still have to pay them the overtime under California law for the hours they worked over 8 hours in a day. Whereas under federal law, if you kept them under 40 hours for the week, you would not be paying overtime. So it's just really important. Your employee handbooks have to be tailored to each of these different states. It becomes very burdensome the more states you have employees working in. And in case you're wondering, it is lawful to say you can remote work from every state except XYZ. And I'd say the most common example of that we see is California, because California's laws are so employee friendly. It's almost virtually impossible to have independent contractors in California. The law is weights so heavily to the employee side that a lot of employers say we just won't allow our employees to work from California, and we're not going to have any independent contractors who are based in California either. So that's a high level overview of some of these issues. I know that wasn't directly what you were asking about. Oh, and then one last thing. You mentioned what's called qualification to do business as a foreign corporation. Every state has a law in this regard, but if you want to get the benefits of your corporate status and the legal protections that go along with that, if you have an employee in a state, if you have an office in a state, or if you have some other substantial connection to the state, also, some states' charitable solicitation registration laws require this as well. Then you have to what's called qualify to do business as a foreign corporation in that state. You have to maintain a registered agent, and most states require that you have to file an annual report and pay the fee that goes along with that. So it's very complicated in terms of what states' laws apply. I would strongly advise you to not wing it when it comes to the stuff. The penalties can be severe if you get the stuff wrong. We deal with a lot of this on the back end to help clean it up. But anyway, I hope I didn't overload your mind, Amy, with too much information, but hopefully that was helpful.
Well, thank you again, Jeff. This has been, usually we ask our speakers to stay on to answer any questions from their presentations, but your presentation has been answering questions. But as Jeff has said numerous times, you are welcome to send him email messages about if you have anything. This is not a plug for Jeff at all, but I will say that over the years, I have asked him questions just in social situations. I know lots of other people who use his services and he comes very highly recommended. So I just throw that out there because his firm does a great job and he is very generous with his time and his answers. So thank you again, Jeff. We really appreciate it. I've learned a great deal. And let me just tag on everything that Jeff just said about where you register, how you do your bylaws. There's like 36 states that have really simple bylaws for incorporating your organization and nonprofits. And then there's the other ones. Just going and asking those types of questions is a huge benefit to your organization, something you want to think about. And I actually work for an organization right now. There's only 14 states that we can have employees work remotely, and all the rest are not allowed because of so many of these regulations. I just want to queue up that we are having another session on December 18th. It's again the third Thursday of the month at 4 p.m. It will be an ethics session. The speakers as Ann Link and myself. We may have another person joining us that has not been decided at this point in time. The main focus of that conversation will really be talking about scenarios. And so we will be reverting back to our previous way of doing things, which is we will be having breakout sessions. If you do attend, you can get your one CAA ethics credit for the year, but you do have to participate in the full session. You cannot drop out early, which sometimes people do, and then that doesn't count. So I wish everybody a happy Thanksgiving. And Jeff, I will leave it up to you if you want to stay on for any more conversations. I know some people have to go at this point in time, but thank you again. Really, really appreciate this conversation.
Yeah, thank you, Clarissa. Thanks for the kind words. Thanks everyone for your great questions and for sticking around. If you have any follow-ups, always feel free to reach out. I put my email address in the chat and check out the resources on our website. So with that, I am going to sign off. It's time for me to get working on my
You got to work on your drink.
More old fashioned.
So maybe you'll share the recipe with Tom and I, and we can circulate it to everybody else, and just so we have that corn old fashioned for making Thanksgiving dinner. So it's just a plug.
No, that you do it. I use mezcal sometimes. That's I don't know if you like mezcal, but
I love mezcal, but I'm excited to try this new corn infused Mexican whiskey that I have not.
Yeah, it sounds really because I do a lot of.
I just put into the chat kind of the list of the ingredients. It's not really a recipe per se.
Yeah, no, it sounds really good. Look, I love it. So have fun, enjoy, and party at your house next time. All right.
Sounds good. Have a good night.
Thanks.
All right, thank you.
Yeah. Okay, take care.
Hey, Tom.
Yes.
I'll let everybody else drop off.
Yeah, everybody's taking off. Yeah.
Okay.
So,
two things. Polly may have sent me a message. Polly was going to be our third speaker, and I don't know that she's still available. So I will catch up with her. She's got jury duty. But Ann and I have already, Polly and I had already put the presentation pretty much together. And so Ann's like, I've already invested too much time. I can't drop out of this now. So
no
we will
worries.
have it next week.
No worries.
But I know that you mentioned that you're getting your hip. What is it? You're getting replaced? Or knee?
My left knee. Yeah, it's my my knee joint.
Knee joint.
Well, it's
so
knee,
I just want to make sure.
It's joint replacement. It's not the whole knee, of course, but yeah.
That's
so having said that, maybe Lewis or Tom or whoever could, because it could be about they say you bounce back pretty quickly. So it's the week after. It's the 12th, and yours is the 18th. So I'm glad you mentioned it because I wasn't sure. We talked about on the Excel spreadsheet that maybe the week prior to like the 11th of December.
Want us to move it to the 11th?
Well, it's really up to you, honestly. And
let me ask Polly and Ann if that's a possibility, and then we just send out the message. And
so let me get this straight. Polly and Ann, is that
no, Polly is one person and Ann is another person. And then
How
me.
strange is that to have Polly? Now, if her name was Anna, it'd be even funnier, but it's Ann.
Yes.
How close? So,
Well, it could be Ann and Polly. I could say it that
Pollyanna, I
way.
mean, how
Ann and
close did I get?
Polly
Yeah.
and me. And I can reach out to them and ask them. So would that work better for you on the 11th?
Well, yeah, just it's up to you also because in other words, well, actually,
Okay.
no, that would be the day of. That'd be the day before. You say that'd be the 11th. My guess is the day before and the night before. I'm going to be probably pretty busy
Yeah, I
with
think so.
stuff
So
getting
let's just keep it on
ready.
the 18th. Let's just make